Okay, great. Good evening, everyone. First of all, I would like to welcome you all to this wonderful seminar, and it's going to be very informative. As the Indo-American Chamber of Commerce, in the series of seminars we have been doing, which were very useful and which are very useful, this is one of those the series, and this will be an exciting seminar. And first of all, I would like to thank for your time and attending this seminar. And I would like to welcome Manjulji to welcome everyone and speak a few words and address the gathering, the seminar. For you have to unmute, Manjulji. Manjulji, you have to unmute.
One second.
Maybe I should. Let me unmute her.
I think I'm trying to do it.
So this will be an exciting seminar, and the details what Neerajji will be sharing with you. But meanwhile, the seminar is all about latest changes in immigration, which is a hot topic and which affects a lot of immigrants too. So as Manjulji is joining, I would request Atma Dayalji, who's the president of India American Chamber of Commerce, to say a few words as Manjulji will join. And
I have unmuted. That's all right. Thank you so much.
All right.
I'm unmuted. It's worked, whatever you're. I just like to welcome all of you to the Indo-American Chamber's meeting of tonight. And our speaker would be Mr. Virender Swami. The Chamber has been there since 1990. And we have the mission of the Indo-American Chamber of Commerce is to promote the needs of business owners and professionals and to advance the commercial, financial, and civic interests of all the Indo-American community. And the purpose of ICC is also to increase participation of the Indo-American community in the mainstream. We have many committees like business mixers, program, membership, special projects, international trade, and all of you are requested to join. It's very easy to join the chamber. We have had many programs, and all of you are here are invited to participate. Thank you.
Thank you, Manjulji. Now I'd like to request Atma Dayalji, who is the president of Indo-American Chamber of Commerce, to say a few words and welcome the attendees for this seminar. Atmaji?
Yes, I had to unmute myself. Well, I'm just going to kind of move forward with what Manjulji said. Again, really appreciate everybody who's joining us on this webinar. And it's a very current topic that's relevant to a lot of people and a lot of businesses. All these immigration changes that are happening, and sometimes they happen so fast that you can't even keep up with them. So who better is to talk about it and tell us more about it than Virender Goswami, who's been practicing in the Bay Area for several years and is also a good friend. So welcome and thank you for joining us in this webinar.
Thank you, Atmaji. And before we get started, this exciting seminar, I would like to introduce Neeraj Bhatia ji. He's a CPA and he has been accomplished accounting professional for last 35 years in the international and domestic tax planning. And he is also, a key member of Indo-American Chamber of Commerce, and he's heading Neeraj Bhatia and Company. So I would like to welcome Neeraj Bhatia ji to be a moderator for this seminar and introduce Mr. Virender Goswami.
Thank you, Dilip ji. As you know, my name is Neeraj Bhatia. I'm a CPA. I'm a chartered accountant from India. We are practicing at both the places. We are a full service accounting firm. I have offices in Pleasanton and Santa Clara and in New Delhi, And as I said, we are a lot of focus is of our practice, which is a full service accounting firm, is on international tax compliance and regulations. Today we are excited. I'm also the president-elect of Indo-American Chamber, and today we are very excited to have Mr. Virender Goswami here to present on the immigration, some of the latest changes which have been there. So in this seminar, we'll be covering 3 very hot topics on the immigration front. One is basically with the advancing of the priority dates, visa priority dates, especially in the EB3 category for India. Various options have opened up, such as downgrading from EB2 to EB3 options. So Mr. Goswami will take us through the pros and cons of the same. Then second topic would be on Department of Labor's wage level changes, which went into effect on October 8th. And it changes the wage levels for H1B and for certain green card categories. And the third would be the H1B, basically the definition of specialty occupation, the key based on which the H1B visas are granted. So there are some proposed changes, and Mr. Goswami should take us through that. So I'll just tell a little bit about Mr. Goswami. He's one of the, in the Bay Area, probably most of the people know him. He's one of the senior most and well-respected immigration practitioners in the US, with a track record that spans over 3 decades. He has been a pioneer in finding immigration solutions for clients from all over the world. He has established an excellent working relation with the immigration officials and has obtained visas in all kinds of professional categories. He is even acted as a practitioner liaison with the District Council of US ICE. He has vigorously and successfully represented clients in immigration cases before several forums, including federal district courts and US Court of Appeals. He's lectured internationally and has written numerous newspaper articles about immigration law and has appeared on television and radio as expert commentator. So without taking any more time, let me bring in Mr. Goswami. Welcome, Mr. Goswami. Thanks for joining us for this evening.
Well, thank you so much for having me. It's been a long time since I've attended a meeting of the Indo-American Chamber of Commerce, and I'm totally remiss in that regard. My apologies, Manjulji, Atmaji, Neerajji, and all the attendees. I hope by tonight's presentation, I'll be able to make up for it. So the topic that I was given to speak on was the changes in the immigration law or recent changes. Well, since President Trump has shown up on the scene, there have been changes every darn day. So I think one of the things that I want to mention outright is I am going to focus on the H-1B wage and H-1B law changes that occurred on October 8th. And I also want to talk about the EB2 to EB3 downgrading and how does that, work. It's a little complex, but I think the Indo-American Chamber of Commerce, those who belong to it have taken the immigration journey themselves and may perhaps appreciate what I'm saying, although the complexity has become much deeper. So what I'd like to do is to start with my PowerPoint presentation. I'll have my law clerk here assist me. Janelle.
Hello people. Good
Hello.
evening.
Okay, great, thank you. So first of all, I myself am the principal attorney of Goswami and Associates. We're a law firm that has 4 attorneys working, and we purely focus on immigration law, although we may be soon expanding into bankruptcy areas as well. I have been practicing immigration law since 1987 and have seen the whole gambit of the changes in immigration law. But the combined experience of our legal professionals in our firm is around 98 years. There's already been an introduction given about me by Neerajji, so I won't get into that. And the topics that I'm going to discuss in the order of priority is the adjustment of status from EB2 to EB3 or employment-based category 2 to employment-based category 3, Then I'll open it up for questions if there are any. Then I'll go into the Department of Labor wage updates and then H-1B amendments. But before I proceed further, usually what happens is most attorneys, when they are dealing with the immigration area of law, they deal with the application. And if the application gets denied, then they go through a motion to reopen, reconsider, or they appeal it to the Administrative Appeals Office, which is all the executive branch, and they just rubber stamp the decision. Well, what we do is, if there's a denial, we take it directly to the judicial branch, the district courts, and we have filed a lot of district court actions where there's an H-1B denied. We've taken it to district courts. We got those approved. If cases have been pending for a long time, we have sued them through a writ of mandamus, and we got those applications adjudicated and approved as well. So we are in a litigation mode in our law firm. We are not waiting for this whole system of delay and denial, and we just go ahead and take them to district court and sue them. So we are more aggressive in that area now. No more of paper pushing, more of creating law in the court, so to say. So we practice in the district court, plus also in the Ninth Circuit Court of Appeals. We take a lot of cases there. We are a full service law firm handling all these matters. So let me go into EB2 to EB3. So let me explain how visas are distributed. Every year in the United States, there are 675,000 immigrant visas granted. And this includes the family-based and employment-based. I'm going to be talking about employment-based today. In the employment-based category, there are 140,000 visas, each either globally distributed for the various countries to avail of. So each country has its own demand to its own quota. Some meet the quota, some don't meet the quota. India, unfortunately, is oversubscribed. So every year on October 1st, beginning of the fiscal year, there are 140,000 visas that are given globally. Unfortunately or fortunately, the family immigrant visas this past fiscal year were not fully used. So 250,000 of these unused visas in the family-based visa category are now being used in this fiscal year in the employment-based visa category. So in the permanent immigrant-based preference system, there are 5 categories. First is person of extraordinary ability, outstanding professors, researchers, multinational executive managers. They get around 40,040 visas globally. Then the second category is members of the professions holding advanced degrees or persons of exceptional ability in the arts, science, or business, another 40,040. Then you have skilled workers with at least 2 years of training or experience, or professionals with college degrees, another 40,040. Then you have unskilled workers, 5,000 visas. Then you have in category 4, special immigrants, 9,940 visas. And then you have investment visas, another 9,940. To the 140,000, you add another 250,000 visas. Now, if you look at India, although there's, in all the categories, there is oversubscription, meaning in EB1, that's category 1, there is more demand and less visas. But if you go to EB2, there's an enormous amount of demand, because that's for people with master's degrees or bachelor's degrees with 5 years of post-baccalaureate experience. There's a huge, huge demand, and therefore there's a huge backlog. Similarly, in EB3, there is a demand, but not as much as EB2. So moving right along here. Now, what is a priority date? I think most of you would know what a priority date is. A priority date basically determines the order of visa availability. Every month, the Department of State provides a monthly determination of visa ability for each family-based or employment-based category. These are called the final action dates. So the visa bulletin is published by the Department of State. And as I said, it establishes the visa priority date. If an immigrant petition has been approved and the priority date falls within the cutoff date in the appropriate visa category as indicated in the visa bulletin, then an alien or a foreign national may submit his or her adjustment of application within the United States. Now, by comparing the priority date of the petition to the date in the visa bulletin for the employment-based category, the petitioner will have an idea of the approximate waiting time for the visa availability. Now, when you look at the Department of State priority visa bulletin, when you look at it, it gives you two things. It gives you the final action dates. So what is this final action dates? The final action date in the visa bulletin shows which priority dates have become current. For those whom the priority dates are current, green card applications are ready for approval right away, so long as they have been filed. Now, what is a filing date? Filing date tells us in the Department of State Visa Bulletin, it tells us when can the green card application be filed so that when the final action date becomes available, all the processing has been completed to issue the green card. So in other words, in the Department of State, there's a visa office. In the visa office, there's a guy called Oppenheimer. He's an old timer who's a great statistician. He determines the visa availability. He says, okay, for India, the visa is going to move up. So what we'll do is within 3 to 4 months, the priority date may become current or whatever it is. Let us have the applications filed in advance so that when the priority date becomes current, then we will just go ahead and issue the green card. So in other words, all the paperwork is done in advance. You do not file the paperwork when the final action date becomes available. Now, the Department of State gives a filing date, which only applies to visa processing in consular offices, whereas the USCIS decides whether it'll adopt the filing date of the Department of State, or it gives its own filing date, or it does not give a filing date. Depends upon where the priority dates are. So, looking at the October 22 visa bulletin and the fact that 250,000 more visas are going to be thrown into the mix globally, the EB2, the employment-based category 2 final action date or priority date for India, for those born in India, is September 1st, 2009, meaning anybody who filed a labor certification or I-140 petition on or before September 1st, 2009 can get a green card. Can you imagine? That's an 11-year wait. Now, for the EB3, the priority date or the final action date is January 15, 2010. But for EB3, people can file adjustment of status, but they have a filing cutoff date of January 1st, 2015. So in other words, those who have a final action date, they can file for adjustment of status application. So what does that mean? So basically what that means is that if you have a priority date, which is until January 1st, 2015, you can go ahead and file the adjustment of status application. You can go ahead and do that under EB3. And under EB2, if you have a priority date, which is till May 15, 2011, you can go ahead and file the adjustment of status. Basically, there's an expectation that the priority dates will move forward during this fiscal year. Therefore, they're saying, okay, if your priority date is Jan 1st, 2015 or before under EB3, go ahead and file for the adjustment of status. Or under EB2, if your priority date is May 15, 2011, go and file it right now because the numbers are going to move forward. So that's exactly what that means. Now, the question is, if somebody is EB2, why would they want to move to EB3? Well, beneficiary with an approved EB2 and EB3 petition will be able to adjust status based upon whichever petition first has a current visa number. So it's basically what we're doing is we're taking the underlying perm application, and what we're doing basically here is we're using that one perm application, which was used in the EB2, and we're going to use it in the EB3 as well, and get that approved and see which priority date becomes current first. And then, boom, we will go ahead and get a green card. So we having two bites to the apple. We get the EB2 approval, which we can keep. You can file multiple applications, and you also have the EB3 in your hand as well. That is why you want to downgrade from EB2 to EB3 and maintain the EB2 as well, the application of I-140 approval, as well as maintain the EB3. So as I indicated, there is a forward advancement in the final action date and filing date in the EB3 cutoff date for India as compared to EB2. Now, individuals with approved EB2s can file a second new I-140 petition requesting downgrade to EB3 category, provided that individual's job duties are same or similar to the EB2 petition and are with the same employer. So it should be with the same employer which filed the EB2 application. Now, then an individual can retain the priority date of an EB2 I-140 petition and apply it to another I-140 petition in another EB category. So once you have a priority date established and you move it to another category, you can maintain that priority date. It doesn't change. So moving right along, now there are questions, when you file a I-140 petition under EB2 or EB3, the questions arise. There is what is known as a labor certification or a perm application that is first approved on the basis of which you file the I-140 petition. So the question is, can you use one labor certification for two I-140 petitions? And the answer is yes, you can do that. But you can only use one labor certification approval for one green card. Well, obviously we don't want two green cards. So in other words, you can file multiple I-140 petitions based upon one approved labor certification. Therefore, we are able to move from EB2 to EB3. Now, I'm going to stop right here, and I'm going to open it to questions if anybody has any questions, because that's a lot of material I just shared. So if anybody has any questions, please feel free to ask me those questions. How can I get the full screen?
So everyone can share their question in the chat box.
So Neeraj, will you just ask the question to me?
Yeah, I will
Why
ask
don't
the
we do
questions. Yeah, sure. As soon as somebody says, I'll ask those questions. But in the meantime, could you also highlight, while everyone is writing the question, that what was there was a confusion when the dates were announced, because USCIS was in a dilemma whether to allow it or not allow it. So there was some confusion when the priority date were announced at that time between the filing date and the final action date.
Well,
so, and then they did some clarification.
Well, it's been published. It's in the visa bulletin. Yeah. So it's absolute now. So basically, I don't think there should be any issue in filing the adjustments now. I think the confusion was more in the area of, about using, there was some rejections I've heard in the mail rooms of these applications because some of the applications did not have a copy of the labor certification, and there wasn't much clarification on that, and there may have been some rejection on that account. But it's very clear now that people who have priority dates in the EB3 till January 1st, 2015 can file for adjustment of status right now, and so can the kids and wives, and they can then avail of the travel documents and work permits. Similarly, You can also do a downgrade from EB2 to EB3 by filing a new petition and not an amended petition, because the amended petition will then destroy the EB2. You will lose it. So that's become absolutely clear now. The regulations permit multiple filings of I-140s. There's a new field memo that creates a little confusion saying you can only use one labor certification for one approval, but that's only for permanent residents, frankly, not for just one I-140 petition, because the I-140 petition does not grant you permanent residence.
Yeah. So there's a question from Chintan Mehta. We have heard that USCIS is returning downgrade applications. Could you please shed some light on this?
Yes, no, they're not. I mean, they are going to accept these. They cannot, because number one, I think 8 CFR 204.5E clearly establishes you can file multiple I-140 petitions. They have done so in the past. In the past, when China, EB3 went forward, then EB2 for China, they accepted it. This past precedent. They cannot go ahead in the middle now change their regulations. There seems to be some confusion. They should not be rejecting it. And such action would be deemed arbitrary, capricious, and violative of law, frankly, and is totally ripe to take to district court. So there may be rejections, they're erroneous, they can't do it, and I think such kind of cases should go to district court.
Next question is from Abhishek Agrawal. If the filing date is current and not the final action, will we still get green card, or we need to wait until final action date becomes current?
No, you have to wait till final action date. Let me tell you, when you get the reason why people do EB2 to EB3 is to retain the EB2 approval and priority date and get a new EB3 approval and priority date, and then wait which final action date will become current to receive the green card. So to answer your question, by filing the adjustment of status with the filing date, you don't get the green card. You just file an adjustment application, then you wait and see which final date will become current first, EB2 or EB3. So let's say you did a downgrade from EB2 to EB3, and filing an I-140 petition, and you file an adjustment of status application. Then you wait. And then let's say EB2 moves forward more than EB3, then you can request that the adjustment application is already on file, and please adjudicate it on the basis of EB2. So to answer your question, you have to wait for the final action date to become current.
Yeah, but one of the advantages, like two advantages could be getting the employment authorization and the advanced payroll by filing 485.
That's correct. That's one advantage. The other advantage is you got two approval,
Right.
I-140 and EB2 and EB3. You never know which is going to run faster, the hare or the turtle.
Right.
So basically, you just sit back and say, okay, now I've got two. Let's see which final date's going to come forward come first, and then you go from there.
Yeah. Then Jagdev Sandhu is asking, does the employer need to be the same for EB2 and EB3 while doing downgrade? I think you answered.
Yeah, the answer is yes. Now, this is where it gets interesting. So therefore, let me explain. When you get an I-140 approved, when you get an I-140 petition approved, if the approval is more than 180 days, the beneficiary, the foreign national, owns only the priority date. In other words, if the beneficiary moves to another employer, then you have to file a new labor certification, a new I-140, but you can use the old priority date with the old employer. So in this situation, the question you're asking, it has to be the same employer. Now, what you can do is, so long as the previous employer, employer A, now that he's working for employer B, employer A, has a genuine need for him, then you can downgrade from EB2 to EB3 and file the adjustment of status. And they should put supplement J in that package saying, yeah, we do need him. And then after 180 days, if it's the same or similar job with company B, you don't need, you just basically port the application to the new employer. So after 180 days of pendency of the adjustment of status. So that way you skip the whole labor certification and I-140 application process.
Aman Rangras has a question. How long will the process to apply for a new I-140 under EB3 from EB2 take, assuming the individual is with the same company and has an approved I-140?
How long does, I'm sorry, could you repeat that again? How long?
How long will the process to apply for a new I-140 under EB3 take from converting from EB2, downgrading?
Okay, from EB2 to EB3.
Yeah, basically, how long will I-140
How long does it take?
take?
Okay, well, once you file the application, I don't recommend you do premium processing initially. I recommend that you go ahead, do the EB2 application through the normal EB2 to EB3, I-140 through the normal processing time and file the adjustment at the same time. The reason being you may get the whole package rejected. But once you get the receipt of the I-140 subsequently, you may request premium processing. Now you need to understand, we are putting in a photocopy of the labor certification, and premium processing is not allowed where a photocopy of a labor certification is put in. But we have heard reports that they do within 15 days approve it if you do premium processing. Otherwise, the I-140 can take from 6 to 8 months through normal processing times. But if you're born in India, there's no hurry. You know, basically, because you've also filed the adjustment of status. And once you file the adjustment of status with the I-140, you can do it concurrently. They will be adjudicating the I-131 and the I-765. Now, there could be an argument. One could say, well, they want the I-140 approved first before they would give the work permit and advance parole, but they should not do that. But who knows what they will do. They may just say, well, we want the I-140 approved first, then we'll adjudicate these, though they should not be doing that. Because I've had cases where I've filed for I-140, they've not been adjudicated, and I filed concurrently I-485 applications. They've gone ahead and approved the EAD and the travel document.
Okay, next, there's a question from Vivi. I've recently switched jobs. My new employer is in the process of applying for a perm. I have an EB2 I-140 petition from my previous employer with a priority date of October 2011. Do I have to first apply for perm with my new employer and then file 2 I-140s, one for EB2 and EB3? Any other routes, given that there can be a retro case during this time that it will take to get the labor certification?
That's a long question. I'm getting old. Got to go slow for me. All right, so let me understand this. Okay, so the question is,
so it's basically a new employer doing it.
Yeah, let me understand the question. Employer A has gone ahead and filed everything, and an I-140 is approved. That's sitting there. Now she is at employer B, and they have filed a perm. Is that correct? Am I right?
So what I understand is I think he's now trying to, with employer B, he's trying to do 2 I-140s, one for EB2 and one for EB3, 2 new I-140s. He already has an I-140 from the previous company and now doing 2 new I-140s from the new employer, both EB2 and EB3, and then whatever works first.
Why is the employer doing both EB2 and EB3?
Well, so again, whichever happens first, that's his question actually.
Okay, so my first question to the individual who's asked this question is, do you have a good relationship with employer A, and they can basically do a downgrade?
No, I think he's already gone to EB2. He's already moved to the new one. So he's talking of with the new employer, basically.
Okay, with the new employer. With the new employer, you can basically go with EB2 or EB3. If it's the same position and you have conflict, I'm sorry?
No, in any case, I think perm has to be done, which itself will take 6 months. So the story will be whatever will be what happens after 5 to 6 months.
Yeah, of course. If the question is, can you avail of the EB2 under this new downgrade situation in October? No, but let me say something about this. because there's an inflow of visas, it is anticipated that up until September of next year, there will be a lot of progress under EB2. So wait till wait till the 24th of every month and see what the visa bulletin says. Okay?
Okay, next question is from KS. Is international travel allowed while the application is being filed from EB2 to EB3? If not, then for how long?
Well, if an application for EB2 to EB3 is being filed along with an adjustment, depends upon whether the person is on an H or L, status and has a visa stamped in their passport. Because what happens is when you file an EB2 to EB3 and then you file for adjustment of status, you cannot travel until you get advance parole approved. But if you travel and you're on an H or an L, it's fine. It's not deemed an abandonment. But if you're not on an H or an L, it'll be deemed an abandonment of the adjustment of status. So rule of thumb, if you got a visa stamp, it's fine. If you don't have a visa stamp, stay put in America.
Yeah, next question is from Sanjay. How much time it takes to get receipt notice once EB3 I-140 downgrade is filed?
All right, that's a good question. It's taking anywhere between, under the current situation now, with a lot of more filings, it may increase. It's taking between 4 to 6 weeks. So I anticipate it'll be 6 to 8 weeks, at least, if not more.
Kostov has a question. Is there a chance EB2 date will move forward like EB3? Because if priority date is 1 to 2
Yeah,
years,
like I said, there's talk, there's anticipation, but there's no concrete information from the visa office of Oppenheimer that there will be forward progression under the EB2 category. So let's wait and see, but it's anticipated. It's anticipated.
Chintan has another question. Do we need to attach copy of PERM LCA for downgrading from EB2 to EB3 I-140 cost?
Well, it's a procedural question. Yeah, it's necessary. I would suggest that you provide a signed copy of the approved PERM label certification. You definitely put in it and make sure you're not marking amendment, otherwise you lose EB2. Don't do that ever. Be very, very clear about that. So the form has to be very, very carefully crafted. The form has to be carefully crafted. Any mistake, you may lose your EB2. So be very, very clear about that.
Praveen Kumar has a question. My attorney insists that we have to apply the downgrade to EB3 as an amendment, given the returning of application by USCS.
Don't do that.
Mm-hmm.
Sorry, I didn't mean to interrupt you.
No. He says, I understand you said that this is not legal and can be challenged. Now, how do I convince my attorney about this? Is there something that everyone is missing here?
No. I mean, is your attorney the company attorney, or is he your attorney individually? Individually, you can fire him, or you can get 3-4 other opinions. You're getting one from me. You can quote me to your attorney and he can call me. I can talk to him. I don't know what else to say. You have a right to representation, whoever you choose. So it's up to you. But no, don't mark. Okay, let me tell you why you don't mark amendment. And item 2, it's item 2 of the form I-140. If you mark amendment, you're going to lose the EB2. And if EB2 progresses forward from EB3, because there's so much demand in EB3 now, which most likely it will, then you're going to lose that priority date. You don't want to do that. And you lose the priority date in EB3. It's not a good idea. Tell your attorney not to do that. He should put not applicable in item 2 of the form I-140.
Yeah, in any case, there's no risk in doing a new petition. If that gets rejected, the other one stays.
Yeah, just, it's a new petition, period.
Yeah.
Tell your attorney that, please.
Okay, I think we can move to our next topic on the Department of Labor, because I think time also may be a constraint.
I hope those US citizens who've been around for 20, 25 years are not getting bored. If you are, you can always leave. It's okay. I won't be offended personally. But anyway, thank you so much for your patience. So I'm going to go next into another subject topic. And before I do, I want to talk about something known as interim final rule versus final rule. So what Trump did, I always use Trump did, but what the USCIS and Department of Labor have done is they have issued two interim final rules on October 8th. One of the rule was where the Department of Labor went ahead and issued new prevailing wages. And this rule became effective on October 8, 2020, which is later followed by a comment period of 30 days. And it became effective on October 8th. The DOL wage changes became effective on October 8th. And then there's another interim rule on October 8th that was promulgated. It's called H-1B amendments, which has a 60-day comment period after the publication of the rule, and the rule will become effective from December 7th. Now, I want to tell you something about final rule versus interim final rule. The process for the final rule is there's initially a proposed rule made by the agency, DOL or the USCIS. Then after the proposed rule is made, then there's a comment period usually of 30 to 60 days where the public comments on the rules, then they look at the rules, the agency, and then they make their own final rule, and then they send it for review to the Office of Management Budget, OMB, whose division is the Office of Information and Regulatory Affairs. Then they go through the rules, they look at the rules, and then once they okay, it usually takes them around 60 days or so. And once they say okay to that, sometimes it's even more. Once they say okay to that, then there's a notice for publication sent to the Federal Register. And this is usually around 30 days, and then the rule is published. So the administration, the Trump administration, what they did is they waived the review by the Office of Information and Regulatory Affairs. They went ahead and published the rules as an interim final rule, saying the comment period will come later. And their excuse is, well, due to COVID-19, we have to take emergency measures to hire American, and that is why we're doing this. It's totally ridiculous. And they have imposed these interim final rules down our throat a few days before the elections. I think this is also a political ploy, so to say. Plus, yeah, it's a political ploy. Let's just put it that way. Now, moving forward, the interim final rules. Trump administration issued the rules on the basis of an emergency due to the rise in unemployment rate during the pandemic. That's their argument. A large chunk of the H-1B applicants are technology companies. Now, prior to the pandemic, the unemployment rate in technology industry was just 6%. The current unemployment rate in technology industry is 3.5%. There's actually not a very significant difference. So this whole rationale falls on its place. Most of the impact of the pandemic has been on retail, restaurants, things of that nature. As far as large companies are concerned, as far as technology is concerned, the impact has not been that great. So I think, it's much ado about nothing. So what the DOL has done is it's changed the way in which it calculates the prevailing wage when based on the Department of Labor Occupational Employment Statistics Wage Survey. If any H-1B petitioner uses the OES wage survey of the DOL, then the USCIS and the Department of Labor do not question it. However, what the Department of Labor has gone and done, they've increased the prevailing wage associated with H-1B visas, the H-1B1 non-immigrant visas that are for people from Chile and Singapore, and the EB3 non-immigrant visas, those are people from Australia, and the labor certification for green card purposes. So what the DOL did was they went ahead and published these rules, bringing about an increase in the wages, in the prevailing wages, 36 hours before the effective date. So they published them around October 6th or so, early in October 6th, and they made them effective on October 8th. Didn't even give people much time to file labor conditions applications, because they said the wage increase will apply effective October 8th onward. So we had 1 day to file so many labor condition applications so that we would be subject to the lower wages vis-a-vis the increased wages that would occur from October 8, 2020. Also, for the green card applications, which needs an approval of a labor certification, we get a prevailing wage determination. They said, regardless of when the prevailing wage determination was filed, if the determination is made on October 8th or afterward, you're bound by the new rules. Pretty amazing. So moving right ahead. Now let's look at the changes to the computation of prevailing wage. If the prevailing wage, let's take for example, is 1 to 100. Previously, for level 1 people, the wage percentile was 17%. In other words, 1 to 100, the prevailing wage for level 1 people would be $17. Now they're saying it's $45. Now let me tell you who level 1 is. According to the Department of Labor, level 1 people are those who are interns or in training. They're out of school fresh, and you're giving them 45% now under level 1. Level 2, $34. Now it's $62. Level 3 used to be 50%, $50. Now it's $78. So can you see level 3 before October 8th wage has now become, after October 8th, level 1 wage. And let me tell you who level 3 people are. They perform tasks that require exercising judgment and may coordinate the activities of other staff. They're almost supervisory, and they can do stuff themselves. They're senior people. So it's totally outrageous what they've done. They've gone ahead and just increased the wage. And let me give you some perspective. I represent clients in audits before the Department of Labor Wage and Hour Division. And what I do basically is I try to negotiate deals with the investigators, etc. But, you know, sometimes it works, sometimes it doesn't work. Then we go and fight it in the before an administrative law judge. The biggest pet peeve of the DOL Wage and Hour Division was that all the staffing agencies pay level 1 wages to even highly qualified people. They said, if they paid level 2, we wouldn't even touch them. We wouldn't even investigate them. But I think what they've done now is they've gone a step further. And now they're saying whatever was level 3 previously will now become level 1 wage. So what they're doing is they're trying to restrict getting people from abroad, and especially hurting the staffing agencies. So they're restricting legal non-immigrant visas by increasing the wages so high. In fact, some of the wages that used to be say 70,000 are now almost 135, 140,000. So that's how high the wages have gone. Now, since the publication of this rule, a federal lawsuit has been filed against this interim final rule in the District Court of New Jersey. And basically, the argument there is that the procedure that was used in the issuance of the interim federal rule did not follow the proper process of getting comments, proper review. Plus, they said that the data used to determine the prevailing wage are obscure and statistically and economically make no sense. So it seems that there may be a preliminary injunction enjoining these wages. We have to wait and see, so stay tuned. So I'm going to end this part of this presentation at this juncture. So if there are any questions, please feel free to ask through Neeraj.
Yeah, so everyone is welcome to send their questions in the chat box. So, and we can look into that. In the meantime, there was a question on that. Is there anticipation of retrogression in dates in either EB3 or EB2 as has happened in previous year?
Retrogression?
Yeah.
Well, if you dump a lot of applications in EB3,
yeah, they may be.
It could. But then again, there's also an injection of a lot of visas. So who knows? Maybe they'll balance each other out, or maybe, instead of a sprint, it may become a slow jog. So who knows?
Yeah. Manjul Batraji is asking, so all the group pages have increased by about 28% or so?
Well, I think let me go back to my the percentile. I can't see it. Hold
Actually,
on.
I think percentile is different from percentage, so it works in the more in the statistical way. So
yeah, that's right. You're correct.
It may or may not translate into exact percentage. So.
Yeah, it does not translate into percentage. But what I'm saying is, put it in layman's terms. I'm not a statistician.
Right, I know.
It's basically an outrageous increase in the wages.
Absolutely.
And some places, the OES has not even published the wage because they don't even know what to do. They don't even have the data, and they've gone ahead and done it across the board in the whole country.
I think in the Santa Clara County, there is no data right now.
Santa Clara, including Alameda.
Alameda, Bay Area basically doesn't have most of the areas.
That's correct.
Yeah. So if somebody has to file anything, just keep waiting.
Well, no, there is a way of tackling that too, which is a better way. You can use an alternate wage survey. They're very expensive. So you have to kind of like compel your client, you know what I mean? It's cost per page of a wage. Sometimes it varies between $300 to $500. So those are very expensive.
There's a question that Ankita, the candidates which have got selected in the second lottery has deadline of November to file the petitions. If the LCA has been filed in September and approved,
that's fine. You're okay.
Petition,
you're grandfathered.
Yeah, right.
So any LCA filed before October 8th, thumbs up. You're okay.
So
I think we're done with this section.
So I think now we can move to the H1B, the specialty occupation.
Okay, well,
and a lot of things are there in that.
H1B is a 150-page document, which also most likely will be subject to federal court litigation. So let me get technologically hooked up here. Are we okay? Okay. All right. Okay, H-1B amendments. There are quite a few. I'm not going to read the whole thing. I'm going to talk about specialty occupation, which has been the bane for a lot of employers. And the reason being that most RFEs, we have to prove that the job is a specialty occupation. And what is a specialty occupation? Basically, a specialty occupation is one where the job is so specialized, complex, or unique, or it uses a specialized high level of theoretical and practical application of specialized knowledge that it at a minimum requires a bachelor's degree. Now, in the past, the government regulations talked about the degrees saying usually requires, or it is bachelor degrees common to the industry, or it's usually associated to a bachelor degree. Now they said, hey, enough of that. If you are going to, for instance, or for example, going to hire a software engineer, we want to see a computer science degree or a computer engineering degree, period. If you're going to say the job requires an engineering degree, we're not going to accept that. We want you to extrapolate the courses that are in the engineering degree. It could be, a degree in chemical engineering or electrical engineering. We want to see how many computer courses that you have taken, and we want to see there are sufficient computer courses that will at least establish that you have a minor or a concentration or specialization in computer science. Otherwise, we're going to reject the file, reject the case. Many moons ago, I used to file for a software engineer saying it requires a degree in mathematics. Now, it makes sense, you can do coding and all that stuff with knowledge of mathematics, with some experience. Now they're saying they're not going to accept mathematics or physics or economics or statistics. They're saying the degree has to be directly related to the field. The degree has to be directly related to the field. So what they're doing is they're basically truncating. They're making the adjudication more difficult, improving specialty occupation, and they're going to, in this process, try to reduce the number of H-1B approvals. So that's number one. So I'm going to skip forward. Oh, we're already here, and that's it. Well, I want to talk about a few more things. Yeah. Okay. Then one other thing about staffing companies is staffing companies go and they go ahead and they place people at end client sites or third-party sites. And basically what happens is when they do that, there's this whole question about how long is the person going to work there? But generally what happens is when there are people assigned to projects, they get projects for 6 months or a year. Usually the projects are not more than that. So what the USCIS is saying, there should be a definitive period. And they're saying, but the argument is this, and I really had once a discussion about this with the National Security Fraud Detection Unit, which basically concluded that 30% of H-1Bs are fraudulent. And before this COVID thing, I asked, well, why do you guys nowadays give H-1B approvals for staffing companies when they're on projects for less than 3 years? They're saying, well, because every year companies go create their own fiscal budget. So we know for a fact the money is not going to be allocated. Then we are thinking, well, then why should we give a 3-year validity period? Why should we do that? We'll give it for a lesser period of time. So I think that reasoning, that logic is here, that they will give up to a maximum, if it's at a third-party work site placement, up to a maximum of 1 year. That, I think, is the thinking behind it, and that's the rule now. If it's going to be at a third-party work site, up to a maximum of 1 year. Now, otherwise, you can get, a placement if they're going to work for the company on their project or their product, then it's up to a maximum of 3 years, and then an extension of 3 more. Now, if the USCIS, according to the regulations, offer less than 1 year or offer less than 3 years, then they have to give a reason. There was an IT Serve case that came out. They have to give a reason why they're giving less time period. They have to give an explanation. They just cannot high-handedly say, forget it. We're not going to, give you more than, 6 months, or we're not going to give you more than 2 years, and you have to accept it. It's our prerogative. It's our authority. They have to go ahead and give a reason for that. So, I'm going to leave it at this. There's a lot of information here, and I'll open it for Q&A to the attendees.
Yeah, so everyone again is requested to send their questions through the chat for the H-1B. So while everyone they type out their questions, I had a question. Why is H-1B is in such a hit list of the government? They talk as if H-1B is the only immigration problem, and that is a cause for all the immigration problems, whether it's legal, illegal. So basically, it's the legal immigrants who are harassed the most because they are in their hand, who H1 people keep filing every now and then, every 3 months, 4 months, they're doing some filing every 1 year, 2 years, or 3 years they're filing, whereas illegal ones are just there.
Well, let me give you a few. Let's talk about the H-1B, and let's talk about this current administration. Make American, hire American. That's a slogan. It's a political slogan. So politics leads to policy. And then if you've got a marketing genius, then you need a target. So H-1B is a good target because it's easy to show they're taking jobs away from Americans. That's why H-1B is a target. People understand that they're taking away our jobs. So we're going to, mess with the H-1B. H-1B is very regulated, extremely, extremely regulated. It's a pain in the neck. You also have Ls. We have O1s. There are other employment-based visas too, but they haven't made a big deal of it. A little bit for the Ls. But H-1B, I think, is a big political statement. We're restricting it. Look, we're going to save your jobs and et cetera, et cetera, et cetera. But it should be remembered that less than 1% of the high school graduating class in the United States take STEM courses, science, technology, engineering, and mathematics. That is why we need software engineers from India, et cetera. Now, I'm going to be, on the other hand, I'm going to be honest, there is abuse by staffing companies when they're taking very, very well qualified people and paying them level 1 wages. That's kind of an abuse of the H-1B system. So, but where there's some abuse, then you can basically say, look, we're stopping abuse. We're stopping abuse. I had one client, it was very interesting. The Department of Labor Wage and Hour Division wanted to publish his case that they're going to punish him, this and that. They did a lot of stuff. It's all about messaging. It's all about messaging. America needs, STEM people. STEM educated people. They need them because they don't have enough of them. And we will lose our competitive edge. I want to also throw out another number. Doesn't apply to Indians alone, but immigrants pay around, I think I saw a certain figure, I think it related to 2013 or 14 or something like that, around $308 billion in taxes. Undocumented aliens pay $20.1 billion in taxes. And DACA, those kids who were brought here illegally when they were kids, they themselves contribute around 2.1 million in taxes. So I don't know.
True. Yeah. Yeah, but the H-1B basic fee is only $460. But I mean, at the highest level for a big company, the amount can be, the USCIS fee itself could be close to $9,000 today.
It goes up very high, that's right.
With the premium processing also going up.
The premium processing has gone up to 2,500 from
almost 8,960 today. Almost
sorry?
9,000. The fee at the highest level, I mean, if
it is that
8,960, which is 9,000, just the USCIS.
Yeah, but let me explain the fraud fee. The fraud fee, the $500 that they were charging, that goes to the National Security Fraud Detection Unit, not only for basically investigating the H-1B cases, they also, the whole immigration enforcement of fraud uses that fraud fee from the H-1B. H-1B contributes a lot, but that's not what I'm talking about. I'm talking about what kind of image does Trump create? See, we're going after H-1B because we want to protect American jobs. That's the mindset. Yeah. That's why they're going after H-1Bs. And let's be honest about it. I'm an independent. I haven't voted it yet, but I have to call it the way it is. This is the reality. So if there are Trump supporters there, I'm sorry, but that's how this is. Who knows? Maybe I'll vote for Trump or maybe I'll vote for Biden. But that's what I'm saying. Let's call it the way it is.
There's a question from KS. Looks like H4 EAD is now taking 8 to 10 months due to pandemic. Is there a possibility for the premium processing for that too?
Yeah, well, yeah. There is a law that was passed, I think, on October 1st, but there's no notification in the Federal Register where premium processing will be available somewhere down the line. I don't know when. But, I have done writs of mandamus in district court compelling the USCIS to take action on these cases where they've been pending for more than 3 months, and they have gone ahead and adjudicated them and approved them. So if if they're not going to do it, you just sue them. That's all you can do.
Sanjay Bhave is asking, what is the success rate for petition approval in the case of this RFE? But I think the changes have just come about now, so we'll know what kind of RFEs come now.
Stay tuned.
Yeah.
I have a question. Can I ask a question? How do I become a member of the Indo-American Chamber of Commerce again?
I am going to unmute Manjul Batraji. She will welcome you. She's there.
It's very simple. You send it. Just have to say, if you want to be a life member, it's $500. Otherwise, it's $100 a year. So
I think I am a life member. Sucheta ji.
By the way, we were all life members in 1990, but it has changed. So we have all paid $500 again to be life members. So
you have, okay. So I'm going to have more than one life. Thank you.
Yeah.
And I have, by the way, are we continuing, Neeraj, or are we ending?
Yeah, I think, I think we are almost done. We are almost at the close. So
okay, I would like to actually recognize Sucheta Kapuria, who suggested your name as a speaker, and we are very grateful to her. Plus, we want to recognize our directors. So if they would raise their hands as we take their name, you can see them. It's Maria D'Souza, she's our secretary. Bimu Rajdev, who's our founding director. Usha Chowdhury, Om Chaudhary, Neeraj has been introduced.
Yeah.
Atmaji is our president. Neeraj, is our president-elect. And there's myself. And then we have a special guest from Business and Professional Women. Sher Singh is here. Sher, raise your hand. So we have, and all the others who are attending, we thank you. Thank you for your attendance and all the questions you have asked. They were very valuable for clarification. Thank you so much. And thank you to our speaker who was great. So Virender, we've got you. Now you've got to join as a life member. Very simple.
मंजू जी मेरी जिंदगी आपके हाथ में है. My life is in your hands.
Thank you, Ji. Thank you. Thank you so much.
much.
Thank you all for coming. And Neeraj is our host. So let's give him a special hand.
Thank you.
Plus our
Thank you.
speaker, a special hand.
Yeah.
Let's give a hand to everybody. Why
Yeah,
not?
we'll
We all
just-
need
Yeah.
happiness these days in our life. Thank you so much.
Thank you.
Thank you.
And I think
Thanks.
Gulati, is he there? By the way, Neeraj, can you announce the next
Yeah.
program?
Yeah, so we are the next event. We are actually originally scheduled for 4th of November, but then it's too close to the election date. So we have decided to postpone it to, most likely we'll have it on 18th November. We'll just find out the suitability of everyone. So we'll keep it on 18th November. That will be Mr. Gulati presenting on financial planning and financial services investments. So look forward to our announcement from the chamber. That's going to be a very exciting one. And once the elections are behind, there may be probably some more stability on the financial front. At least we'll get a good perspective from Mr. Gulati. So please wait for our announcements on that. Yeah.
And our president might want to say a word. Atmaji, would you like to say a word?
Atmaji, yeah.
I think is he there or is he gone?
Yeah.
Goswami is right here. Can
No,
you hear
no,
me?
Atma, President.
Yeah. No, I was muted, so I guess Neeraj just unmuted me.
Oh,
Yeah,
So, so no, I just want to say, hey, thank you, Virender, for doing this for us, and of course, Sucheta for suggesting. And it was a great seminar, lots of information, and I think if people have more questions, I'm sure that they can contact you. I see your contact information is up, and like I said, I've known Virender and his brothers for several years, and so all hopefully, and I'm hoping that everyone who has joined this webinar will join us on November 18th, which is also going to be a very interesting topic. Is about finances and insurance, many other topics that are related to the financial well-being of everyone. So please join us. Thank you.
Thank you very much.
thank you, Mr. Goswami. Thank you, everyone. Thanks for attending and for spending your valuable time. We look forward to seeing you in our next event. Thank you, everyone.
Thank you, Neeraj.
Okay, good night.
Thank you, everybody. Good night. Be safe. Be happy.
Bye. Thank you.
How do I leave? Oh, there it is. Leave. Okay.